Welcome everyone to this Privacy Rules Privacy Espresso. My name is Alessandro Di Mattia, Legal and Executive Officer at Privacy Rules. And today I'm joined by Magdalena Gad Nowak from the law firm Timelex, because we are going to discuss about a very relevant topic of the moment, that is the one of the EU-U.S. adequacy decision. In particular under the perspective of an EU law expert and the GDPR. So Magdalena, thanks a lot for being with us today, and I would immediately start discussing about this topic. Maybe you can provide us a brief overview on the backgrounds and in particular what's an adequacy decision, because I think this is key to know for our listeners.
Hi, Alessandro. Thanks for having me here. Yeah, for starters, what is an adequacy decision? For those who don't know or have a very vague idea of what an adequacy decision is, well, adequacy decision is a tool envisaged by the GDPR, which allows for transfers of personal data from the European Union to a third country, which, in the assessment of the European Commission, provides adequate level of protection for that personal data, comparable to that of the European Union. What's important, the data protection system of that third country does not have to be identical. It's sufficient that it's essentially equivalent. If indeed the Commission finds that the data protection system is adequate, then the data flows from the EU to that third country can take place unhindered. There's no need to obtain any additional authorizations. There's no need any additional safeguards. They basically happen just as if they were taking place within the European Union. As far as the most recent adequacy decision, or actually a proposal of a draft adequacy decision is concerned, last week, the European Commission launched the process towards the adoption of an adequacy decision with respect to a new EU-U.S. data privacy framework. This decision followed the signing of a U.S. executive order of President Biden from October of this year, which, along with accompanying regulations of the U.S. Attorney General, implement into U.S. law the agreement reached by the European Union, by the European Commission and the United States regarding this new data privacy framework. The adequacy decision, or the European Commission, concluded in this draft adequacy decision that through this new data privacy framework, the United States ensures adequate level of protection, which is comparable to that of the European Union. Most importantly, the new data privacy framework addresses the major concerns that the Court of Justice of the European Union raised in its Schrems II decision of July 2020, which led to the invalidation of the previously existing data transfer mechanism, the now defunct Privacy Shield. So the Commission concluded in particular that by including additional safeguards and additional limitations on U.S. surveillance programs, the new data privacy framework meets the EU necessary and proportionate standard in this, that now access to the EU data or personal data of EU residents by U.S. intelligence agencies will be limited to what is absolutely necessary and proportionate to protect national security interests. Moreover, the EU residents will now have access to meaningful redress regarding the collection and use of their data by U.S. intelligence agency before an independent and impartial redress mechanism that will independently investigate and resolve their complaints, and which will be able to adopt binding remedial measures. The functioning of this data privacy framework will be subject to reviews on an annual basis. The first review will come up 1 year after coming into force of the adequacy decision. Of course, there are certain things that could be better. There are a lot of accusations and allegations that the new data privacy framework will not withstand yet another challenge before the Court of Justice, especially the eternal nemesis of the transatlantic data transfer, Max Schrems, the well-known privacy activist, already announced that he and his organization NOIB would challenge the scheme before the European Court of Justice. once the adequacy decision is adopted. The major accusations, the major shortcomings, so to say, are that the two-layered redress mechanism that the data privacy framework introduces does not meet the qualification of the judicial redress. The newly established Data Protection Review Court within the Department of Justice is merely an administrative body within the executive branch of the US government. Hence, it's not a real court in a true sense. Moreover, there are doubts as to the impartiality and independence of the judges who will be elected to the court, since these will be appointed by the US Attorney General. That's the first accusation. There are also doubts as to the stability of the framework, because data privacy framework was implemented into US law through an executive order of President Biden. An executive order is merely that, an executive order. It's not a legislation. So it can be easily reversed by a subsequent president, like it was in the past when President Trump resigned the executive orders of President Obama. So there are doubts as to the stability of this framework. And also there are doubts as to whether this two-layered redress mechanism isn't too complicated and in fact will discourage EU residents from actually bringing complaints, because first they would have to go to their national data protection authorities, then those authorities would bring a complaint with the Civil Liberties Protection Officer in the United States, whose decision, though binding on the US intelligence agencies, would still be subject to the review of the Data Protection Review Court. So there are a lot of things that could be challenged before the Court of Justice. It is more than certain that Max Schrems will challenge the data privacy framework. The question is whether the court will actually share his doubts. I have mixed feelings. I believe, third time's charm, but we never know. Now the adequacy decision will be sent, the draft adequacy decision will be sent to the EDPB, which gathers all EU data protection authorities. EDPB has usually 1 month to give a non-binding opinion. Then the European Commission will have to consult national representatives of all member states. Their opinion is also non-binding. So even if it was negative, the Commission doesn't have to really observe it, and it could go ahead and adopt the decision. Once the decision is adopted, the transatlantic data flows could, happen freely and without the need to implement any additional safeguards, which is, I'm sure, looked forward to by many companies, not only the major players such as Meta or Google, who have been facing serious problems over the legality of the data transfers from their EU counterparts to the US. But yeah, it is yet to be seen what's going to happen.
Yeah, and I would say many companies from both sides, because we were also discussing with our colleagues from the US, and the issue is for both sides. So.
If I may add, we have to remember that transatlantic data flows are a very crucial part of international aspect of international trade and transatlantic economic relationships, which are estimated to value circa $7 trillion. So it's a very important aspect that needs to be taken into account. And yeah, I look forward to seeing how things go with this new data privacy framework.
And let's keep finger crossed. But Magdalena, thanks a lot. We are running out of our time, but thanks a lot for all this overview addressing various points and your perspective on what is going to happen. Of course, I invite all our listeners to contact you or the team of Timelex if they need support in addressing, in particular, data transfer with countries like the US in this case, but in general. Thanks a lot for your time, and thanks to our listeners for being with us today. I look forward to meeting you all in our next Privacy Espresso. So bye, Magdalena, and bye, everyone.
Thank you. Bye.